Hi, good evening, everyone. It is my real privilege and honor to welcome our distinguished guests for this fireside chat, Paula Hodges, KC of Herbert Smith Freehills, and Eduardo Silva Romero of Deckard. Paula and Eduardo are the leading lights in our field, and I cannot really do justice to all their achievements in my limited introduction, so please do forgive me as I do embark on that exercise of introducing you both. Paula is the head of the global arbitration practice at Herbert Smith Freehills. She has also been the president of the LCIA since May 2019. She has over 30 years' experience in international disputes across the globe and acts as both counsel and arbitrator. In recognition of her advocacy skills, Paula was awarded the title of Queen's Counsel, now King's Counsel, in 2014. She's recognized in all the leading legal directories with chambers and partners describing her as the most complete arbitration practitioner. Eduardo is the co-chair of Deckard's International Arbitration Global Practice. He has extensive experience as counsel and arbitrator in both commercial and investor state arbitrations. As an arbitrator, Eduardo has acted in more than 140 arbitrations. He's a former Deputy Secretary General of the ICC, International Court of Arbitration, and he teaches various subjects: investment arbitration, contract law, French arbitration law, at various universities. So it's a real pleasure to have you both here. You both bring a combined wealth of experience and wisdom, and we will explore today the intersection of your thoughts and perspectives on some of the key challenges and issues that we face in relation to our field of practice. I will start with some questions, and I'll leave some time at the end for all of you to raise any questions you may have for Paula and Eduardo as well. So with that, if I could start from the very beginning. And we know now that international arbitration is a well-trodden path, but it hasn't always been so. And I was quite interested in understanding what was it about the field of arbitration that attracted you when you embarked on your professional journeys in the field of law. And perhaps, Paula, if you could start with you, and then we'll go to Eduardo.
Well, thank you, Manish. I knew I wanted to do disputes as soon as I started studying the law, probably because we focus so much on cases, especially in a common law degree. But I also knew I wanted to do a lot of advocacy. But for various reasons, I decided the bar in the UK was not for me. I wanted to have contact with the clients. I wanted to work in more of a team. So I was recommended to look at Herbert Smith, which I did, and they seemed to like me. So that was good. And then it was a series of lucky chances as to why I got involved in arbitration, because when I qualified, and I'm going to confess, in 1989, it was the year before the Courts and Legal Services Act in the UK, which meant solicitors could get rights of audience, and Herbert Smith, as was at the forefront of making sure all its disputes lawyers obtained their rights of audience. That coincided with the rise in arbitration. The firm also wanted us to specialise in arbitration, and my then boss said to me, "Why don't you focus on arbitration? You get the advocacy you're seeking. It's a new area. I took this as an insult because I'd qualified into litigation. I said, am I not good enough? You want me to go off and do this? But having sort of recovered from the shock, I actually realised he was saying something very sensible, and arbitration was very appealing for me. And then once, of course, I looked into it a bit more, we hired Professor Julian Liu. He talked to us about the cultural richness of arbitration and the mix of common law, civil law, and I was smitten.
And the rest is history. Eduardo, what do you do to arbitration?
Let me thank the organizers first for this invitation, and I don't know if I should thank you for the questions you will ask us, especially these personal questions, which are more difficult, I should say, to answer. And if I may, I will rephrase your question, because I wasn't really attracted to arbitration, but I was retained in arbitration when I got into it. And let me explain. I was in Paris studying more philosophy than law. So I had long hair and I was a happy person. I was thinking, which is an interesting activity from time to time. And so at some point I didn't have any more money. So I came back to my original studies of law, and I started sending several CVs to different law firms, including my first law firm, which was Gooder Brothers, and Julian Liu was at Gooder Brothers at the beginning as well. And I was very lucky because the person who interviewed me was Laurie Craig. Laurie Craig, one of founding fathers of arbitration, together with Julian. And Laurie asked me what I was doing in Paris. So I explained to him that I was writing a thesis on philosophy of law, and I didn't have a lot of hopes after that answer to be hired. But he said to me, you know, this is not silly, that might be interesting. And he hired me. So I started working in this environment without really knowing very well what arbitration was about. But I was retained in the field for two reasons, and I truly believe in these two reasons. The first is that I think we really form a community. There are very common values, many common values that we share, and I should say, I believe we are very lucky because we have the possibility of meeting really wonderful people in the field of international arbitration, very interesting people. And the second reason is that I still believe international arbitration, compared to litigation, which is something I did before doing arbitration, is more flexible, and hence there is a bigger room for imagination, for the creation of arguments, and that I always liked.
Thanks, Eduardo. And I was actually going, before we talk about the broader systemic issues, I was going to ask you both one more personal question. And I recognize that you have been involved in hundreds of cases as both counsel and arbitrator. But if you had to pick your most memorable case, either as counsel or arbitrator, what would that be? Paula?
This is a difficult one. I had a little bit of an advance warning. And it's amazing how you always remember the most recent cases, I think. But I'm going to draw a distinction between that and my very first case, which, so the first arbitration was in Dubai, subject to Dubai law, but was run almost like an English High Court litigation case before 3 former judges. There were British QCs all over the place. But I nevertheless really enjoyed it because we were sitting in Dubai overlooking the beach, and I suddenly realised that we were considering points of Dubai law, the Sharia, how everything intersected. And it didn't really matter that there were mostly British people doing it in the British way. We were actually dealing with very many multicultural legal issues and questions of fact. The only disappointment was that my client didn't show up to give evidence, which is slightly awkward because it was an oral contract. But that aside, I do remember it fondly, but more recently, in the last 12 months, we were getting ready for a 3-week hearing in London, very complicated energy dispute actually, with lots of evidence, almost 20 witnesses, 10 experts, a lot of work getting it together. We were respondent. Shortly before the hearing, our counterparty did want to talk about settlement, but it didn't come off. So we went into openings, and it was very interesting that my opponent, who was the claimant, didn't go anywhere near the evidence and talked about the law in opening, which I thought was probably a good sign. And then I spent the afternoon focusing on the evidence and lots of questions from the tribunal. The case settled overnight, and although I was terribly disappointed that we didn't have the full 3 weeks, I think it said something for all our preparation in advance.
That's fantastic. Eduardo?
It's certainly a very difficult question because every case has something special and there's always an anecdote or two in connection with each case. I mentioned only two, if I may. One, because of the complexity of the case and the time it took to resolve it, is the case between Occidental, the petroleum company, and Ecuador. This is, by the way, a case in which I met a very good friend who is your partner in 3 crowns. It was a fabulous case because investment law wasn't really very much developed, and we had to try many issues from scratch. And we had wonderful opponents, a wonderful tribunal, and I believe this is a case that gave rise to many interesting issues that are still pertinent in the field of investment arbitration. Then more on the side of the anecdote, more as an arbitrator, I recall another investment case. I will not mention the parties, but a state in Eastern Europe was involved. And we had a problem, which was that the main witness relied upon by the investor was being sought by Interpol, and so he couldn't testify everywhere. We tried to find all the places where we could organize a hearing to examine that witness, and we ended up with 2 cities. Bogota, my city of origin, so I was very happy to go to Bogota. The 2 other arbitrators from the UK were not, which I may understand. And the other city was Istanbul, so we ended up the 3 members of the tribunal in Istanbul, and we examined that witness. But the true anecdote is that after the examination of that witness, we went to have dinner with these 2 very distinguished UK arbitrators I will not mention, and after some drinks, both of them disclosed something absolutely unexpected, which was that they deeply disliked their first names. So I thought of mine, and I'm fine with mine. If I could choose, well, maybe Francisco, but Eduardo is fine. But then we ended up knowing that these 2 very distinguished English arbitrators wanted to be called Max and Luke. This is one of many anecdotes.
Well, we moved from that to the theme for this chat and the more systemic issues. And I wanted to ask you from your comparative perspective, what do you think are the greatest challenges that our field faces today? Paula?
I think they are varied, and the things that immediately come to mind are it is much more competitive than it was when I started. Now, there are pluses and minuses as a result of that. It's competitive because arbitration continues to grow. There are more countries embracing it, there are more law firms becoming involved. So all of that is a positive, but it is a crowded landscape, and I think it is more challenging for young people to make their mark. On the other hand, diversity is absolutely top of the agenda for practitioners, and I think for clients, certainly for the institutions. And so there is a lot of willingness, there's a lot of encouragement for people to get involved in arbitration all over the world and to become arbitrators as well, which I think is great. Other challenges, certainly the mix of different legal cultures that are involved now means that everyone wants to bring a little bit of their home jurisdiction to arbitration, which I think on the one hand is a good thing, provided that we don't enshrine all of these different principles, guidelines, rules, because otherwise it will become too complex and we will stray away from the core values of arbitration, which are, I think, creating a bespoke process to resolve disputes. So I think that's a challenge. And then AI. Something that I mention with trepidation. Technology is not my specialist subject unless it's a dispute and I've got all the facts before me. But I can see that there may be certain areas where AI can be helpful in maybe summarising issues. But I remain wary about it replacing the wonderful analytical skills that all the people in the room bring to bear on arbitration, the evolving cultures. And I think AI is only as good as the information that goes into it. But maybe I'm a dinosaur and I'm boxing at shadows.
I'm happy to be a dinosaur as well on that front. The two challenges I think are very relevant. One was mentioned today and another was not, I believe. The first is all this issue of transparency, which has many consequences in international arbitration. Arbitration of ESG disputes, this transparency really is there in arbitration to adjudicate this type of controversies. Then the issues of disclosures, not to say over-disclosures, but more fundamentally regarding independence and impartiality of arbitrators. What I truly believe is that we are creating very demanding standards, which are theoretically probably sound and correct. But then we need to contrast these standards with messy realities. Let's only think of the fact that in the field of arbitration, even if it is bigger, we happen to work with the same people, against the same people, with the same arbitrators quite often. And we may be more or less friendly to all these people. So we are applying to the field of arbitration criteria that are not recognizing that very fact, that in a profession there are relationships. So I'm convinced that we need to keep applying those standards, but at some point what the IBA calls the green list should be rethought and probably augmented just to recognize that messy reality that I referred to. And then the second challenge I see more in Europe is let's forget ACMIA, but let's speak about the attitude of the European Commission vis-à-vis international arbitration. I'm very concerned by the fact that at some point the European Union, meaning the European Commission and the European Court of Justice, may expand this allergy against arbitration beyond intra-EU investment treaty arbitration. There is already a small element to be worried about, which is, you may be aware of, a decision by the Conseil d'Etat in Greece, which characterizes an international contract as an international investment contract and applies ACMIA to it to annul an arbitral award rendered by an LCAA tribunal. So you see how this ACMIA stuff is being expanded to other realities, and that's not good for all of us in Europe.
Paul, I wanted to pick up on something that Eduardo said about, application of standards of independence and impartiality. And there is a concern that perhaps we are not striking the right balance there. Maybe we are moving towards a world marred by over-disclosures and as a result, precipitating technical challenges. And I wanted to get your views on that, both in your role as counsel and arbitrator, but also from your vantage point as the president of the LCI court as well.
I'm happy to do that. Obviously, in the UK, we're likely to have a positive duty to disclose this time next year, not before, which I think is a positive development. It's quite clear that arbitrators operating in the UK should disclose if that was in doubt. And sometimes you do come across certain arbitrators that don't think they should be disclosing things. I've had a couple of awkward instances recently where we have approached arbitrators to act in a case where we know that somewhere in our firm, which is obviously a large firm, 20-odd offices, they've been appointed twice before, or once before rather, because we wouldn't go to three, once before by us. And then they said they accept the appointment, but then when they are liaising with the institution, they don't actually disclose. And so we've had to give little nudges to them, which amazes me in this day and age. But leaving that to one side, when I mentioned the core values of arbitration earlier, and I said it's a bespoke process, but underlying that bespoke process is the impartiality of the arbitrators and their ability to give an unbiased, fair award. They're not beholden to a particular court system. On the whole, there isn't a right of appeal. So it is absolutely crucial that the arbitrators remain impartial and independent of the parties. If I'm honest, less concerned about independence, and maybe that's going to Eduardo's point, that the arbitrators may know counsel, they may have done something for the party years before, or whatever. The most important thing is impartiality. So certainly as counsel, we would only recommend to the client arbitrators that we think can, absolutely stand up to that standard, and you can shine a light on their fairness and credibility. Otherwise, there's no point in appointing them, because you don't want to achieve an award and then for it not to be upheld. Wearing my LCIA hat, and as president, I and my vice presidents appoint all of the LCIA arbitrators that appear in cases, whether they're nominated by parties or we select them. It's a particular characteristic of the LCIA. And we always err on the side of caution and put all disclosures to the parties. so that they see what each party, what each candidate has said before they're appointed, so that we're trying to make sure that the arbitration process is an effective one and that we don't have many challenges down the road. So, of course, there is a concern we could veer into over-disclosure, but I think if the parties are aware and agree, that's got to be a good thing.
Thanks, Paula. Just talking about challenges, I mean, we have surveys of users of arbitration year after year telling us that they are choosing arbitration despite its speed and costs, rather than as it once was because of those features. And I wanted to pick your brains on if there was one thing that you would change and improve about the arbitral process in this regard, in terms of the efficiency and the speed, what would that be? Perhaps we can start with Eduardo.
Oh, thank you, Manish. Yes, that seems to be an obsession that has lasted for the last 10 years, that the arbitration process needs to be more efficient. And this obsession seems to come from someone I haven't met, called the user. There are some clients, I guess, but the user, I don't know who that person is, who that company is, because the clients, or many of them, seem to be satisfied with how the arbitral process works. And I should say that if the process is properly conducted, you can have a decision, not in 6 months, not in a year, but in 1 year and a half, 2 years, you can have an award in a commercial dispute. So I have a problem with the main proposition. Now, a second idea that comes to mind is that many people, to fix the problem, have suggested to add additional stages in the arbitration. I find that a bit contradictory. If we want to be more efficient, do we really need all these interim hearings or more generally additional stages to get to the end? It seems counterintuitive. My only proposal would be very simple. I think the only way to become more efficient is to get the award rapidly. And for that purpose, I see there are two solutions. First, to eliminate the proceeding briefs. The proceeding briefs, many times, frankly, don't add anything. I have a friend who is your partner who calls proceeding briefs in good Spanish a refrito. Refrito is something that is left from the last day in the fridge, and then you take it the next day, you warm it and you eat it. If you were properly prepared as an arbitrator before the hearing, if you paid attention during the hearing, the proceeding brief shouldn't really have. So that's first. And the second idea, which is a bit more problematic, is that there should be some obligation on the arbitral tribunal to prepare a draft award and deliberate on this draft preliminary award, if you will, before the hearing. The tribunal should arrive at the hearing with some preliminary draft award, and then in the hearing they can correct it, complete it, but then the deliberation will be far more efficient. Because what I've seen recently is that arbitrators have become very efficient in organizing the deliberation after the hearing, or a couple of months after the hearing, or just 1 week after the proceeding brief. But then the problem is the drafting of the award. It takes really a lot of time. So if you commence really in advance, perhaps arbitrations could be more efficient. It's very difficult.
I think I'm still very much counsel, because that fills me with horror. And I can see that you could draft the framework of the award and you know, the endless procedural steps that certain institutions, not the LCIA, require. I think it's good for arbitrators to talk about the issues in them, but I think, you know, I prefer the drafting to happen afterwards. Just going back to cost and time, and it is definitely a recurring theme. But what I find with my clients, it's a recurring theme till it's their case. And then they want every stone overturned. They want to be able to tell their board, yes, we have done the best possible job in bringing the claim, fighting the case. And so I do find it slightly ironic, actually. So that's from a counsel point of view. From an arbitrator point of view, I do sometimes get irritated by parties who bring endless procedural applications which are completely unnecessary. And I remember when two Ukrainian oligarchs were slugging it out, where I was presiding arbitrator once, and we'd had, I think, the third or fourth round of interim relief applications. I got a bit bossy and said, the main evidentiary hearing is in 6 months. I encourage both sides to now focus on getting ready for that rather than these procedural skirmishes, and the case settled within a week. So I'm not quite sure what was going on. Maybe they were worried about what I would decide at the end of the day. In any event, what would I do to change things? Certainly in terms of bespoke procedure, and this applies to arbitrators and counsel, not just opening the bottom drawer and bringing out the last procedural order number 1 that you have to do, but actually trying to get to grips with the issues very early on. And it may not be possible to do it immediately, but certainly you can put a provisional timetable in place, have the first round of submissions, and then have another hearing to talk what really is at the core of the dispute and how can we do this more efficiently. We don't have to spend a lot of time doing it, but it may be that you don't need expert evidence. It may be that you don't need endless document production. You know, just thinking about what the case entails. And the other idea, which goes back to the award, because I do agree with Eduardo, it takes a lot of time to do a sort of singing and dancing, fully reasoned award. And I think as arbitrator, I'm going to ask the parties more. At the end, do you really want a 300-page award with every single issue that's been raised, being analysed? Or do you want us to focus on what I hope would be the list of issues that the parties agreed by that point, and just give you the main reasons for that? Because I think that would speed things up enormously. We'll see what the answers will be.
Eduardo, can I just follow up on that? Because this recently came out in an interview with a co-arbitrator where we were talking about potential presiding arbitrator candidates. And our appointed co-arbitrator, in reference to one candidate, said, look, you're going to get an award very quickly. Are you really worried about quality, or are you worried about speed? Mm-hmm. And it's a tough question, because obviously you want both. And but when you're sitting as an arbitrator, you're often trying to manage these competing considerations, right? You're worried about quality, of course. You're thinking about efficiency of the process. You're thinking about due process or the paranoia associated with that. And I'd be very grateful for your views on how do you go about kind of managing those, and what are your reflections on that?
Yes, well, there are a couple of ideas. As Paula mentioned, a policy by one institution will not mesh. Given very, very strict deadlines to send the draft award. And obviously we may understand the rationale behind, but I should say, as an arbitrator, 3 months or 2 months to draft an award after the hearing or after the proceeding brief is a short period of time. It's a short period of time. You need to go back to the file, reflect upon the issues, read again, hear on the other submissions. summarize many things, deliberate with your colleagues, and one of the colleagues perhaps dissents, and you need to provide the dissenting arbitrator with enough opportunity to say her or his views. So it's not that easy as if you draft something, you say to your colleagues, well, this is it, sign it. So the 3 months, 2 months may be a problem of administration of the process, and also a problem of the quality of the paper. I happen to be a member of the court of that institution, and frankly, from time to time you see draft awards filed on time. The quality is not there. The quality is not there. So that's something that deserves more reflection. Now, the same institution, the ICC is. You haven't guessed. The ICC is reflecting upon what Paula mentioned, and perhaps there is something that the LCA and the ICC should do together. Is what is the bare minimum award needed? Because the 300 pages are useless. You need the decisions and the main reasons for the decisions. So what they are trying to check is whether this is acceptable in different jurisdictions. If there is a consensus of jurisdictions that this is enough, perhaps we can have a 40-page award or 20-page award, and that will be it.
Paula, did you have any further views on that?
I was just thinking that probably got some more IPA guidelines coming out of writing awards, but it is something that I think we could all focus on. And I know as counsel we all hate agreeing the list of issues, but we really should know what the main issues are by the time we get to the end of the arbitration. I do wonder, the parties agree those issues and the tribunal then just focuses its attention on its reasoning for the issues and what the decision is. I think that would speed it up.
That's very helpful. I was going to move on to a different topic about diversity and inclusion in our field. And again, Paula, if I could start with that. Of course, we are seeing a much greater emphasis on improving gender parity, improving all other forms of diversity and inclusiveness in our field. Now, again, in your leadership roles, both at Herbert Smith and at the LCIA, I was very interested in your insights on how do you see that movement.
So I'll start with the LCIA, and the LCIA signed up to the pledge for equal representation arbitration when it was quite rightly introduced. And at that time, Judith Gill was the president. I was waiting in the wings, and of course Jackie is the Director General, so you had 3 ladies in quite powerful positions at the LCIA to make a difference. And we decided that from that point onwards, unless there was a particularly quirky case where there were only male candidates, every shortlist of candidates should have at least one female candidate on it. And as you've probably seen from our statistics, when the LCIA court appoints arbitrators, we are almost at parity. We've got as close as 49%, we're not quite there yet, so we'll keep going. But what I've seen is it's had an impact on not only the court appointments, but slowly but surely party appointments are getting closer. Co-arbitrators are doing much better when they're choosing presiding arbitrators, but I'm afraid we're still in under 20% for parties, and in about it varies from co-arbitrators about 20%. So there's a long way to go. But it was really by just focusing our minds on making sure that females appeared in shortlists, making sure those candidates had more of an opportunity to be considered. We're now doing the same with first-time appointees. from all over the world, all ages, because obviously we're not going to put a first-time younger practitioner as presiding arbitrator on a multi-billion case, very complex case. It wouldn't be fair to them, it's not fair to the parties. But all institutions have smaller cases, or if it's a debt case, and having a younger, enthusiastic, passionate, driven arbitrator is a good thing. And so what we're trying to do is mix that up. And if it's a common law case, it doesn't have to be an English law, it can be an Indian lawyer. There's civil law. It can be French law, but with Swiss arbitrator or whatever. But just really pushing the boundaries. And our stats have now gone up. Last year we had 71% of new appointees. And by giving people their first appointment, we hope that will then enrich the overall pool of arbitrators, and then council co-arbitrators will feel able to say, yes, this person's had experience, and then they'll get appointed again. And so I'm very passionate about it, as you can tell. Now, I'm going to swap to when I'm counsel. I have to say I am less brave when I am making recommendations to my clients. In that I want to see some experience from the person. 9 times out of 10, it's because they've appeared as an arbitrator before. Not necessarily I've appeared before them, but someone has. But I've also sort of tried to train myself that if I know it's a very able practitioner, I've appeared opposite, or I've seen them at a conference, we'll do it. But I want to see some experience. As a firm, though, we have a database of arbitrators that everyone, not partners, trainees, associates, everyone can add names to when they see someone. And we have an arbitrator of the week, so someone that isn't as well known, that goes around the whole arbitration practice, encouraging people to keep thinking about new candidates and not just focusing on the people you know very well. And you might have seen one of our alumna, Eula Cartrick, just produced a really good article about usual suspects and the psychological process that we all go through. I really recommend it to you because it'll challenge your thinking. Now, I'll be quiet.
No, it's fascinating. Eduardo, I wondered whether you wanted to add something about
diversity.
Well,
Well, a couple of ideas, because I agree totally with Paula. The first is we should, however, even if a lot of improvement is still needed in our field as far as diversity is concerned, I truly believe international arbitration, if you compare it with other fields in law and other disciplines different from law, is perhaps one of the most diverse fields. I mean, look at this room. From all countries, all cultures, and pretty even women and men. So we should, I believe, be proud of that diversity that we have already conquered. Obviously, we need to keep working on it. Another point of diversity which is different, is more complex in my view, which is who really can have access to the field of international arbitration. Think of people coming from poor economies, people who may be brilliant, but don't have the means, the resources to study at Oxford University, to mention only one. So I think diversity is also about providing opportunities to those who don't have the resources to get into it. And I think law firms, institutions, universities are doing a lot by offering scholarships to many people, and thanks to that, people who had never made it into the field do it.
Thanks so much. I was going to move on to some practical aspects, particularly for some of the younger members and not so young like myself. uh, and we'll all benefit from your guidance on some of these points. And why don't you start with oral advocacy? Now, you're both some of the finest advocates in the world and also see others ply their trade as advocates before you. Now, what advice would you give to those of us in the room as to what really works and what doesn't work? But perhaps, Paula, if you could start with you.
Thank you. And I would say that sitting as an arbitrator has, I think, helped me hone my counsel style. At the end of the day, I think it all comes down to credibility. And it's credibility in the sense of knowing the case, so that you can distill the issues for the arbitrators. Of course, you're going to be championing your client's case, but you do it in a balanced way. You recognise the good points that the other side have, rather than ducking them, and explain why they're wrong. And engendering trust from the tribunal in what you're saying, not running all of the perhaps rather more irascible points that your clients would like you to make, but persuading them that it's much better to present the case in a persuasive but balanced way. So what I would, and being as calm and composed as you can, rather than aggressive and banging the table. I always think iron fist in the velvet glove is the better approach. So, the witness on the other side don't see it coming. But I'm now going back more to my counsel preferences. But I think credibility and preparation are the keys to it all.
I couldn't agree more. Eduardo?
I also agree. I would add a couple of ideas, perhaps. I very much believe in a principle you may know, which is Occam's razor. Occam's razor is a principle in logics, pursuant to which there may be two different demonstrations of the same proposition. The simpler is always more convincing. So I would recommend to simplify as much as possible the presentation of the case and the issues. I truly believe that in the oral pleadings in international arbitration that may last 2 hours and a half, 3 hours, at times 5 hours, the entire day, if we didn't convince the tribunal in the introduction, in the first, let's say, 30 minutes, the pleading is not good. So the introduction of the pleading is essential. You need to convince the tribunal there, and the rest of the pleading is simply to elaborate on those premises or propositions that were already established in the mind of the tribunal.
Actually, can I just add one point? Memory for me. I was doing one case which was about an air traffic control system, and I outlined to the claimant, and there were, this is quite terrifying if some of you knew which country it is, 45 problems with this air traffic control system, and my team were passionate about all of them. And when we were preparing the opening, I said, right, what's the top 5? And we had a very, very hard-fought debate about whether or not we should be limiting. I said, there's no way I'm going to go through 40 plus defects in the opening, or indeed cross-examination. We've got to pick our top 5. It's all in the submission, it's all in the expert evidence. You don't need to go through each and every one. So we did pick the top 5. Needless to say, trajectory prediction was one of them. But anyway, luckily we did win the case, so I wasn't taken over to task by the team. But I think everyone was absolutely right. You've got to pick your best points and make sure those are the ones you focus on at the hearing.
So we move from your kind of counsel role to arbitral appointments. And Paula, you mentioned as to how the field is quite competitive, but also there is a bit of a dilemma despite the focus on improving diversity, as counsel, when recommending arbitrators, you often face this challenge in terms of experience. But just for those who are looking to get more arbitral appointments, what would be your advice in terms of securing arbitral appointments?
Well, I don't think there's one size fits all. Prerequisites are definitely experience of arbitration, you don't say. But no, seriously, proving yourself as a practitioner, I think, is really important. But that can be, it doesn't have to be first seat counsel. It's someone on the team. I'm always looking out for good young people. I remember saying Manish many years ago. You're looking for the good people in the room. So that's the first thing. Yes, you should certainly write articles, try and think of those thought-provoking new ideas or young, talented people in the room. We, as a sector, love our subject. People love to read new ideas, so do that. Do get involved in the young practitioner organisations because you're building your own network. Sometimes you invite oldies like me along and we get to see you and then, can recommend you in due course. But don't only go to the young practitioner events, go to the larger events too. And I know it's a crowded space, but you need to get to know the people who are more in a position to appoint you. So you need to get to know your local institution. That's how I did it. And I guess in London it's easier. You've got the LCIA there. But it's a mix of ways of showing that you have experience. Obviously, tribunal secretary is another way of doing it. And then trying to get slots at conferences so people hear you and think, oh, yes, that person's got a great experience and I'd really like them to be arbitrator in a future case.
I agree with all of that. On my experience, the first appointments one gets come from the institutions. And then over time, you are appointed by the parties or the co-arbitrators. So any way in which you can be closer to the institutions, I think is a good way to start building that possibility. You can take the president of the FCA to take some drinks, for instance, after the session. But more seriously, participating in all these young arbitration conferences and the other conferences as well is a way to go. There is a second way I've seen being very successful, which is the one, is what I would call the Swiss model that has been adopted to some extent by other arbitrators from other jurisdictions, which is to appoint secretaries to tribunals. I have worked over the years with many great lawyers who have been secretaries to tribunals I have presided, and I'm very proud and happy to say that all of those are today arbitrators being appointed in their cases, living their lives, having abandoned me over the years.
I'm conscious of time, but with the organizer's permission, I wanted to raise one question before we open the debate to audience as well, to put their questions to you, and that's predictions for the future. Now, as leaders of global arbitration practices, as prominent counsel arbitrators, and holding prominent roles at various institutions, how do you see international arbitration evolving in the years to come? And what does that really mean for all of us in this room who are hoping to manage that change?
I say only one prediction, which is already happening. I think we are seeing the decline of investment arbitration. We need to take that reality, but that doesn't mean that investment disputes will disappear. because investment will continue flowing, and the states will continue receiving investment. That's how the economy works, and I don't see that the model will disappear. What will happen, in my view, is that the treaty disputes will be increasingly contractualized. We will see the resurrection of something that the French professors invented called state contracts, including very well-tailored clauses to ensure that the investor is properly treated. We will see what was called investment contracts with stabilization clauses in it. And so all these disputes that gave rise to so much criticism, not only from the states, but also from the investors, will be classic commercial arbitrations based on contracts.
Eduardo, I would add, recently we just had a dispute coming out of a contract with the state, which had a whole BIT built into it. So going beyond stabilization clauses, actually building in substantive protections into that contract, which was quite remarkable. It's kind of evidence of the trend that you're highlighting. But Paula?
I think arbitration's here to stay. I know I'm a glass half full person, but the world is ever more connected. I think cross-border business, investment from various companies in countries all around the world will continue, and I think arbitration will be an appealing and effective form of dispute resolution in those cases. So I think it's here to stay, but I think we've all got to be conscious that we will be held to task that we do it in a proper and appropriate fashion. So professional conduct, I think, and ethics, which was one of your panels earlier, will be ever more important, and we should hold ourselves to account, because I don't think we'll get a supranational body to do that. And then it's AI, and of course some of you have seen in the UK that a couple of practitioners are already testing a sort of hearingless, documentless process. But I think that's fine for straightforward cases. I'd like to think that arbitrators won't be replaced by bots anytime soon, but maybe that would be good in some cases, I don't know.
With your permission, could we perhaps invite some questions from the audience? Any? Please.
My question kind of draws on the two topics we discussed, AI that you just mentioned, but also the procedural efficiency difficulties. My view is that a lot of the kind of commentary about the use of AI has been focused on practitioners as opposed to arbitrators. And obviously the kind of junior practitioners of today can be arbitrators for 5-10 years from now. And the use of AI is quite paramount now. And I think addressing the issue of procedural efficiency, I can envisage some arbitrators perhaps uploading all the procedural, all the pleadings, all the documents onto a generative AI platform and asking for a summary, creating a precedent award, for example, or a draft award. Is that something that you've kind of thought about from an institutional perspective, and difficulties and challenges with that? Are there any thoughts at the moment about introducing kind of new rules about that to manage that?
Shall I start? Just in terms of the LCIA, we're monitoring it, but of course one of our USPs is confidentiality, and it's written into the rules. And we are very sceptical about finding, a system that arbitrators could upload all of this confidential information onto, and being sure that it then produces an adequate award. And maybe that will change over time. But I think party consent is absolutely essential to all of this.
As we established before, we are dinosaurs on that. But I think AI really puts a very important ethical/philosophical question, which we should ask ourselves and try to respond, which is this: what kind of justice we want. So far we have a justice of human beings for human beings. Do we want something different? And to be more specific, I've been working recently on the relationship from an academic perspective, on the relationship between equity and arbitration. And I'm not speaking only of the amiable composition or arbitration in equity. That's not the issue. The issue is that equity is always present in the adjudication process, either because applicable law refers to equity or otherwise. And so how that element, which is so essential in the resolution of many disputes, would be considered and applied by our computers. That I don't know, and that you know creates some anxiety. So thank you for your question.
Please come.
I'd like to draw the issue. Draw the issue of the decline of VITs and the contractualization of the investor-state disputes. So, including in your case, Manish, the way I see this is against the backdrop of a more nationalistic mindset of states that we've seen throughout the world, whether these contracts for the resolution of disputes would be most likely subject to domestic legislation and seated within the country that is receiving the investment, or if you see it otherwise. As an example, you have Brazil that obviously is not party to any VITs, and the petroleum disputes, the oil and gas disputes are being resolved, many of them via arbitration, seated in Brazil, subject to Brazilian law, unless there's certain exceptions. Is that what you have in mind, or just what do you think about it?
Now that Paula advertised so much the LCIA, let me advertise a bit the ICC. The ICC Institute of World Business Law, together with UNIDROIT, have undertaken the analysis of that very issue. First of all, whether there is that decline. Second, how to provide an instrument to states and investors to continue resolving disputes. And so both institutes or institutions are working on a model investment contract. There will be variables there. Obviously, the parties may choose to have the UNIDROIT principles applicable to that contract, but it'll be difficult for the states to accept that. I agree with you, and the states will push for the law of the state to be applicable. And then the other variable is the seat of the arbitration. Would the seat of the arbitration will be in the same state, or they will accept that it be fixed in London or Paris or one of these arbitration centers. But we are studying the problems, and hopefully, well, this is not very reassuring. In 1 year and a half, 2 years, we will have the result. UNIDROIT is a complex institution.
Perhaps we could take one more question, or you? Okay, we have scope for one more question, perhaps.
Yeah, I just want to. Oh, thank you. Hi, yeah, my name is Eduardo. I'm a student at the Cambridge University at the VII program. I just wanted to make a follow-up question on the future of arbitration that was discussed here. So, I think it's known to a lot of people that sanctioned entities somehow encounter some problems with payment of arbitration fees. Nowadays, I think that LCA maybe doesn't have such strict policy, but some institutions do have. So my question is, do you think that this will somehow affect the future of arbitration? For instance, if sanctioned entities will go to DIAC or CIAC, though the process there is less effective, but are these circumstances in any way that can affect the future of arbitration? I think that's more like a discussion.
Okay, So I just want to clarify that we do not have a lax process at the LCIA. The LCIA has been able to facilitate arbitrations involving sanctioned or designated parties because we were able to persuade OFSI, which is the regulatory body in the UK, to give us a general license rather than at the beginning we had to apply for a specific license every time, and it was just slowing everything down. So we've been very fortunate that we've been given the license and the ability to do that. And I would encourage all countries to take a similar approach, because I think the ICC has struggled as well to get that license. And it just seems to me that even if you're a designated or sanctioned entity, you're still entitled to bring claims or fight claims and, your access to justice. And so I think as the institutions, you should be given licenses to facilitate that process.
Nothing to add.
Thank you.
Thank you very much. I'm sure all of you would agree with me that we have all been beneficiaries of a tremendous amount of insight and wonderful perspectives from two of the most distinguished thought leaders in our field. So please join me in thanking them in the usual way. Thank you.
Eu uso esse ou esse? Oh, hi everyone. It is sad that I'm bringing the message that the 7th Oxford Arbitration Day is coming to an end. My name is Ana Carolina Dallagnol. I'm one of the organizers of this event. Our intention with organizing the Oxford Arbitration Day is to invite those who have their finger on the pulse of the arbitration market to come share their insights here in Oxford on the most topical issues of the year. I hope you have enjoyed the discussions as much as we had. As expected, this event was only made possible due to collective efforts. First, to our attendees, thank you very much for coming here and engaging with the speakers. We've reached a full auditorium today at Wolfson after the pandemic, and it's nice to see my college hosting this arbitration bonanza once again. To the speakers, thank you very much for your preparation and for sharing your insights with generosity. And thank you for those traveling from other countries and continents to join us today. To the sponsors, thank you very much for empowering us to make this event happen. So to Grant Thornton, Kamsa CBC, Skadden, Chaffetz Lindsay, Nardello & Co., Arnold & Porter, Kincaid, XG, IVS, Three Crowns, and Lefosse Advogados, thank you very much. And lastly, thank you to my friends and colleagues who have done a lot of visible and invisible work throughout this year. André Luis Monteiro, Grace Ferrier, and Xuan Shao, who is now doing her postdoc in New York. Thank you very much. Thank you also to Julia Tomasiak. She already left, but she assisted us today as well. And also a big thank you to Lauro and his Arbitration Channel for your amazing support. And as you know, the Oxford Arbitration Day has fundraising goals. Due to our partnership with the Educa Foundation, the funds that we raised with sponsorships will feed a needs-based scholarship for a future LLM student. And we are happy to confirm that we were close to affording a new scholarship. And we are also happy and proud to share news about Leonardo Souza McMurtry. Leo was the recipient of the Educa Foundation scholarship when he completed the LLM at the Queen Mary University of London as a Chevening Scholar in 2019 and 2020. And he's starting his PhD as a Gates Scholar in Cambridge this year, and we're very proud of that. It could have been Oxford, but Cambridge is not too bad. Thank you again for joining us today, and have a great weekend. And also for speakers, moderators, sponsors who are joining us for dinner, please stay here as a meeting point. Thank you so much.